All right, the defense can give its closing argument.
When a family breaks apart, it is a tragedy, with the devastation far-reaching, affecting many people. I am not exempt from tragedy, none of us are. But what we learn from it is most important. Because of this experience, I've studied the law and the judicial system, and that knowledge will stay with me forever. When we experience tragedy, we can grow stronger from the experiences, and then those experiences are not all negative. You would think that often people in my position would feel defensive or angry, and from where I'm standing, I understand that very well. But I don't feel any of those things. You have watched me under pressure, under scrutiny, and even under attack. And I have shown you that I'm not on any of those things.
I'm going to object to character evidence and testimony that's not in evidence.
Ms. Daybell, could I have you pull that microphone a little closer, please?
You can't be upset with people who are forced to look at your life from a distance or judge it through a lens that's being intentionally distorted or being at least very limited. Like the lens the state has shown you on this event. There's so much more going on that is not included to your view. The law prevents some of these things from being shared
I'm
in
going to
trial.
object, Your Honor, to improper.
Sustained.
You have seen opinions formed by strangers trying to put together a narrative. I have shown you that basically there is no defense to what a person did not do or did not participate in. Other than what you've seen, which is no evidence that I made an agreement to commit a crime, because no such evidence exists. So I'm not defensive. I'm not angry. Nobody has all the pieces to this puzzle. It is complex. Like most families, this is a complex issue. And like the state, I was not there. But there is no agreement, no plan, no game. I am no stranger to tragedy. The breaking up of a family is tragedy. On June 25th, 2019, Brandon Boudreaux decided that I was responsible for his family tragedy. And I'm really sorry that he feels that way.
No, Your Honor, I'm going to object again to testimony.
All right, the jury is reminded that what is said in closing statements or closing arguments is not evidence, it is not testimony. The intent of the closing argument is for each side to argue what the evidence shows. Go ahead.
I did and have supported my niece Melanie when she suffered tragedy as a young child and during this terribly difficult time in 2019. We read the text from Brandon to me on June 25th, 2019, where he claims that he will never stop until he proves that I am responsible. Well, here we are, almost 6 years later, and I'm charged with conspiracy to commit first-degree murder. In order to have a conspiracy, 2 or more people have to make an agreement to commit a crime. There is no such agreement between me and my brother Alex, although I did love my brother Alex.
And I'm going to object again, Your Honor, to testifying.
Sustained.
There is no agreement that was shown to you between myself and Melanie Boudreaux, although I love Melanie.
And I'm going to object again to testifying.
Sustained.
I cannot tell you what happened that day on October 2nd, 2019, because I was not there.
And I'm going to again object to testifying, and please strike everything the defendant has said.
All right. The defendant is admonished. You cannot argue things that were not admitted into evidence.
The prosecutor wasn't there. Law enforcement wasn't there. Only Brandon knows what happened before he called 911. Only Brandon said he will not stop. The fact that I supported Melanie in her time of need does not make me against Brandon. I had nothing to gain by Brandon being hurt. Brandon has worked with law enforcement for almost 6 years to make sure that I pay a consequence.
I'm going to object to misstating the evidence.
Sustained. The jury will determine what the evidence did and did not show.
Your job is to determine if I committed a crime. This crime. A conspiracy, an agreement, not cleaning out a garage, but an agreement to commit murder. You did not see an agreement. You did not hear an agreement. You heard Detective Duncan say that he had spent hundreds of hours going over my iCloud accounts. They have 19 years of my accounts. Text messages,
And I'm going to object to misstates the evidence and no.
If there was an agreement.
Hold on. The objection sustained. The jury is reminded that they will determine what the evidence did and did not show. Go ahead.
If there was an agreement, they would have showed it to you. There is no agreement. We've all experienced tragedies in our lives, and naturally people want someone to blame, someone to pay a price. My brother is no longer here. We can't ask him about that day. There were things presented in this case that I did not know.
And I'm going to object again to testifying, Your Honor, and ask to strike.
Sustained.
Things that I saw, I thought,
And again, I'm going to already ask to strike.
All right. The defendant cannot testify to things that were not testified to from the witness stand.
because this is the theory the prosecutor wants you to see, it is limited. How can we say clearly when the law only allows for a skewed view of things? The devastation this family has gone through is the tragedy. After almost 6 years, it's time for healing. Thank you.
State wish to give a rebuttal, close.
Thank you.
All right, the state has the burden to prove the defendant guilty, and since they have that burden, they have the right to open and close the argument. Go ahead.